Well, good morning, everyone. Thank you for joining us today for our program, FOIA Changes, Filing, and Tracking. We have a fantastic pair of presenters who will be sharing their insights and expertise with us today. Before I introduce them, please note that there will be a Q&A session near the end of the program. So please be sure to drop your questions into the Q&A or chat sections at the bottom of your Zoom screen. You can do that throughout the session or a few minutes before it ends. We are recording the webinar and we'll send it out to everyone in the next day or two. We will also send out a survey afterwards, and we'd be grateful if you would take the time to fill it out. It's short, so it won't take more than a minute or two of your time, and will be extremely valuable as your answers will help guide us in developing future programs tailored to your needs. Now, let's dive into the introductions of our presenters. Our first presenter is someone many of you probably know, Megan Ryan. She has worked for the Virginia Coalition of Open Government for 25 years and became its executive director in 2008. Megan also serves as the administrator for the National Freedom of Information Coalition and Knight Litigation Fund. Before arriving at VCOG, she served as an opinions editor for Texas Lawyer newspaper in Dallas and was a freelance writer at Androvet Legal Media in Dallas and the National Law Journal in New York. She was an adjunct professor of media law at Hampton University's Journalism School and first became interested in open government while a Freedom of Information intern at Reporters Committee for Freedom of the Press. Her law degree is from the University of Colorado Boulder, and she was a radio, television, and motion pictures major at the University of North Carolina, Chapel Hill. She lives in Williamsburg with her husband and teenage son. Our second presenter is Ian Kalish. He is a clinical supervising attorney at Reporters Committee for Freedom of the Press and a lecturer at the University of Virginia School of Law, where he teaches in the First Amendment Clinic. Ian's practice includes matters of access to public records, court access, defamation, government employee speech, and right to protect. He frequently litigates in state and federal court. Prior to joining the Reporters Committee, he was a lecturing fellow at Duke Law's First Amendment Clinic. He began his career as a litigation associate at Cahill Gordon. Through VPA's partnership with the UVA School of Law, Ian also oversees the VPA's FOIA hotline, which is a free service to VPA members and their staff. Thanks to both of you for being with us today. The floor is now yours.
Great, thanks so much. Let me go ahead and share my screen here. Is that sharing? Great. Yeah, sorry for the few seconds of technical maneuvering there. Thanks so much for having me today. Looking forward to presenting with Megan. I figured because we have people attending with various levels of experience with FOIA, the plan is for me to provide a little bit of an overview of the statute, particularly with respect to the public records provisions. And in doing so, I'll also provide some high-level advice, some strategies to help you best make use of the statute, best track your requests, stay on top of everything. Then I'll kick it over to Megan, who will share some of the updates to the statute that have been enacted over the past year and go over some potential changes in the future. And then we'll wrap up by sharing some common issues we see and some general takeaways about the statute before opening up for questions. But anyway, I'll just get into it. So when thinking about the Virginia FOIA statute, particularly with the public records provisions, it's important to start with what the statute provides for. So the statute provides for citizens of Virginia, residents of Virginia, to make requests for public records that are in the custody of public bodies, right? So those two definitions are going to be important when you're formulating your FOIA requests. So a public body is defined in the statute as any legislative body, authority, board, bureau, commission, district, or agency of the Commonwealth, or any political subdivision of the Commonwealth, including counties, cities, and towns, municipal councils, governing bodies of counties, school boards, and planning commissions, governing boards of public institutions of higher education, and other organizations, corporations, or agencies in the Commonwealth supported wholly or principally by public funds. So it's not the easiest definition to remember, but it's important to refer to this and think about that when you're thinking about who you could submit a FOIA request to, right? So I think some things are obviously, or some entities, agencies obviously fall under this definition. So as a faculty at University of Virginia, UVA, for example, is clearly a public body. It's sort of a state created school. Falls under sort of this definition here as sort of a public institution of higher education. I think that the trickier questions are connected with sort of this final catch-all provision, or not catch-all, maybe that's not the best word, but this final more broadly worded provision for other entities supported wholly or principally by public funds. So this is the one where you see a lot of the confusion about, it's not entirely clear, what wholly or principally supported means. It's a question of fact that there's often back and forth about. I think it often comes down to sort of the number of funders an organization has, like the percentage of money that they're receiving that is public. But that's just something to keep in mind. That's sort of one of the open questions in the statute. But basically, the statute only allows you to access the records of these public bodies. Well, let me rephrase that slightly. Records in the custody of those public bodies. So it is possible to receive records that were originally written, or perhaps like email communications from other people that are outside of the scope of the statute, as long as sort of they were sent to the public body, like the record itself is held by the public body. So that's something to keep in mind. There are ways to examine communications that certain agencies, public bodies have with those outside or private citizens. But when formulating a request is something to keep in mind. So the second of these sort of preliminary definitions are is what is a record. So when coming up with your request, when formulating requests, it's important to remember that FOIA itself, for the most part, is about records, not information. Right. So generally, the statute doesn't allow you to ask questions to a public body and receive an answer. What it allows you to do is specifically ask for documents, records specifically, that the public body holds and you're entitled to receive. There are some provisions in the statute which require particularly like law enforcement agencies to provide certain information upon request, but for the most part, the statute is focused on records. So what is a record? Generally, it's best or easiest to think of records as things that are reproducible. Memoranda, emails, things like that. Things that the agency has, and they could either copy, either physically, like with a photocopier, or just copy an email, something like that, like an electronic file. They're sort of written or recorded documents, records. They're not sort of unique records, like you can't request sort of a particular piece of evidence connected with some type of like investigation or something like that, like not sort of unique physical objects, but rather reproducible documents. With that said, you generally can't ask the agency to create a new record for you. So again, it's sort of things that already exist, things that are held by the agency. FOIA does not require them to sort of write up a memo answering your questions. So those are sort of the two key things to keep in mind and help you sort of think about what you can access through FOIA. When making a request, it's important to specify the format of your records. Even if you're asking for a copy of a physical, like a memorandum or something that might be on paper, you could ask for it in electronic form, if it's scanned. You just want to, be as much in control of your request as you can, ask for the format that is most helpful for you. And sort of my, last point on this slide, as sort of this preliminary conversation is that, when formulating your request, I advise you to not be too concerned about what might be able, or what an agency might be able to withhold versus not. Obviously, I think you want to be aware of, that the fact that the statute has multiple exemptions that an agency can cite to, withhold or redact records pursuant to your FOIA request. But most of these exemptions are discretionary in nature, right? So an agency, there are some that certain things cannot be released, particularly if they implicate, certain very protected privacy interests and things like that. But generally, an agency is free to release things if they so choose. They don't necessarily have to exercise their discretion under an exemption to withhold records. So with that said, I often think it's best to figure out what you really want, try to access it, submit a request, and then, see what stance the agency takes. It's best to sort of at least make an attempt, see what happens, see what stance they take, what exemptions they cite. And then at that point, you could sort of assess your options, figure out if you think that, they're citing something improperly, that you do have the ability to access it under FOIA. You could push back, or, you could say, okay, this makes sense. I'm not likely to get this, and move on. But I think at the initial stage, it often makes sense to just push forward and see what happens. I'll just quickly talk about the process of submitting a request, just the formal procedures. The truth is that there's not much in the way of how you need to submit a request, which isn't to say there aren't best practices involved, which we'll go through as well. So first of all, requests do not have to be in writing. Oftentimes the requests are made over the phone, rather informally. You don't need to write an email, you don't need to send a letter, at least under the rules of the statute. Similarly, you don't need to directly refer to the statute in your request. It's sufficient to just, reasonably specify what you're looking for and ask for them to produce it. With that said, I think it is best practice to make requests in writing, particularly via email. And I think this is important for a few reasons. First of all, the email itself serves as a record, of the request, right? So it's connected with the date you sent it, that's in the email. The specific language, the specific records you requested are written out. You're not having to rely, on, memory to figure out what you asked for or not. Everything's right there. And then their responses to your email are going to be there. You could see the dates of those responses, and I'll go over this a little bit later, but all these dates, are important when you're thinking about the requirements that the statute imposes on agencies in terms of timing. So anyway, I think it's best to communicate an email, just have everything memorialized that way. If you do make requests via the phone, I think it's important that you take careful notes, you memorialize every conversation you have. You just want to have a record yourself of everything that went on and the dates that everything happened. So I think the next tip I have when formulating a request is to be as specific as possible, right? So you can make broad requests. Sometimes you have to make broad requests if you're trying to sort of explore an issue that you don't know a lot about. But if you do have the ability to make narrow requests, it's always better to. The two main reasons why are speed. It's much faster. It's easier for agencies to review a more narrow request and ultimately make productions, and expense. We'll get into this a little bit more, but the statute does give agencies, public bodies, the ability to recoup, the actual reasonable fees of searching and producing records. So the more narrow you can be, the better, because you sort of evade some of those issues. So one way to be narrow in your request is to use things like keywords, date ranges, identify specific names of people that whose communications or documents you're interested in. Just try to think about everything that you know about your request and apply everything you can to sort of narrow it down. I personally think that date ranges are a very effective way to narrow. because they just automatically, you cut out large segments of, potentially responsive records that might have been created or email sent outside of the specific range. So it's just sort of a way to easily like cut through the pool of records. When you're formulating a request and coming up with keywords and things like that, it's generally best to do what you can to avoid, saying things like records relating to X or Y, because those are sort of require judgment. They require someone to be reviewing a record and figure out, oh, are they really talking about this or not? Right. So when using keywords, I think it's a good idea to think about, like them in terms of like Boolean searching, like ask for records that contain the word X and the word Y, or not the word Z or something like that. Just something that doesn't require judgment. Somebody could easily apply to a pool of records to like exclude, records outside of the scope. I was chatting with Megan the other day, and she should have put this, I think, well, in terms of thinking about this as sort of a tech person is going to be filtering through these files, right? It's you just want to give parameters to someone who sort of exists outside of the scope of the subject matter of the records a little bit, and just give them parameters that can be applied systematically, either through like someone's inbox or something like that, to just like cut out, the chaff, from sort out what you need from what you don't. With this said, I think this might be in a later slide, but I guess I'll say it now. Like when you're thinking about narrowing things down, you could also treat an initial request as sort of like a test case, right? You could kind of come up with as specific a request as possible just to see what type of records are there, right? And then you could always follow up with a broader request. So I think that's generally best practice. It allows you to just like narrow in, you get a lot of benefits. You could get a quick response, you get a cheap response, and then it also could guide you, depending on what you see in this initial request, to make a more complete and thorough request down the road. So that's just something to keep in mind. You're not, you don't need to stick with just the one request. You could always follow up. You could always ask for more or tweak what you're asking for, based on the information you see from the initial request. So when you've done this, when you sort of thought about, your initial request, you thought about what you exactly want, you could write it out and submit it to the FOIA officer of the public body. So generally their contact information will be listed on, the public body's website, like the agency's website. If you don't see anything there, you can always directly request for the contact information of the FOIA officer, let them know you want to submit something and you want to be directed to the person who you could email. And then the FOIA Advisory Council also maintains a list of designated FOIA officers. So that's another resource as well. So here's just some additional tips regarding formulating your request. So like I said before, a lot of this connects with just being as specific as possible. So if if you're looking for a specific form that's used by a government body or something like that, or discussion of an initiative or rulemaking or something, you could include the specific title or classification of the record if you know it. If you know what something is referred to as within the public body, you could say that. You could really hone things down that way. Again, you could think about making test requests and then broadening down the road. And like I said before, with emails, this kind of happens naturally, but just make sure you keep track of the date you submit a request, the dates you receive further communications, all of that. And if you are sort of involved in making many FOIA requests to a lot of different agencies and public bodies, sometimes it's helpful to just compile all this information on a spreadsheet or just sort of some centralized tracker where you could keep track of, the status of all the requests, like the dates of all the requests, so you can more easily, figure out if sort of the timeline has sort of lapsed for the agency to respond or something like that. So it's oftentimes easier to have sort of a central location where all that information is stored. So I think I'll just be very quick about, what happens after you submit the request. Generally the public body has 5 working days to respond. So at this point, they could either give you the records, they could provide you, redacted records, they could withhold the records in full, or they could basically say, we need more time. So they do have the ability to take another 7 working days to respond to the request. So these timelines, I will say, are quite aggressive, I think, compared to other states and other public record statutes, particularly federal FOIA. But that's not to say you necessarily are guaranteed to receive your records, after this 7 working day extension runs out. Oftentimes, an agency will say they need more time. There's things are implicated, or the request is implicating a sort of a significant number of records that will take longer to review. So in those situations, the agency can, petition a court for additional time, or just, I think it's best to just work with them to, come up with a timeline that's reasonable and works for everyone. The agency could also indicate that no record was found to their review. There's a little bit of a distinction between them saying this versus them saying, a record doesn't exist. And I know that sort of distinction is important sometimes in reporting. So I think just kind of be aware of the language that the agency, provides when describing the state of the requested records. Generally, if the record is housed or in the possession of another agency, perhaps it was transferred over or something like that, they should tell you who has it, and then you could sort of make another request to the other agency. And failure to respond, if they just don't respond at all to your request, that is deemed a denial, and that's sort of a violation of statute. So if you request the records and the agency doesn't give it to you, or give them to you, or over redacts them, you do have potential recourse if they're incorrectly withholding things or under the statute. There's no administrative appeals. So other states and federal FOIA have an administrative appeals process that you need to go through before bringing a case. Virginia doesn't have that. You don't need to exhaust an administrative remedy before going to court. So generally, the only recourse you have is to file a claim, petition a court saying that the public body violated the requirements of FOIA. However, with that said, there's always the possibility to informally resolve these disputes. So I think it's always best practice generally to follow up with the FOIA officer and push back on a denial that you think is inappropriate. So I think when doing this, it's best to be polite. You're oftentimes going to be dealing with the same FOIA officer over and over again. And I will say many of these FOIA officers do really want to provide records. They do want to be transparent. So I think it's always best to sort of be cordial, be polite, but you could be firm. You could direct them to the language of the statute, the language of an exemption that they're citing that you think they're interpreting incorrectly. You could offer a review of it. You could just try to negotiate, just try to come to an agreement. And sort of this tact, is also recommended when you're dealing with questions of fees. Oftentimes, like I'll talk about the next slide, there are fees attached with requests, and even with those, you can try to push back. And just quickly, the VA FOIA Advisory Council, kind of offers opinions on disputes relating to the interpretation of FOIA. They don't mediate disagreements, so it's not sort of an administrative appeals process, but their opinions do provide, persuasive authority in interpreting questions of FOIA law. So, if you run into a problem and you want sort of a clearer answer, it's also a possible avenue there. And just lastly, just talk quickly about fees. Virginia FOIA doesn't have a journalistic or public interest fee waiver. Other statutes do sort of, have that. They allow journalists to just, cite their status as journalists when making requests and not have all the fees attached to them. But even though Virginia FOIA doesn't explicitly provide for this, it's generally okay just to ask for one anyway. Like I said, with respect to the exemptions, a lot of the operation of Virginia FOIA is sort of discretionary. things might play out differently between different public bodies, different agencies, different FOIA officers, and they don't always charge fees. So while they're able to recover fees, they don't always do it. It's particularly for smaller requests, they'll often provide records without. So I think it just doesn't hurt to say, you're a journalist working on a story that's in the public interest, and see what stance they take. It is difficult to determine whether the fees an agency is charging are reasonable. Like they can recover the actual expenses incurred in searching for records, conducting an exclusion review and things like that. But the reasonability of those charges are connected with the specific request that they're dealing with. Certain requests, implicate the agency or require the agency to do a lot more digging through records, or weigh certain considerations when interpreting an exemption. So each request is different, and because of that, the reasonability of fees is very fact-based, and it's hard to sort of give a firm answer about. So again, that's why I generally suggest to trying to be as specific as possible to limit the need for in-depth review, at least initially, and just try to keep the costs down. If fee estimate, and I guess you could always ask for an estimate. I think now the agencies will are required to ask you if you want one before they proceed. So you could always do that to kind of get a sense for the scope and like what position they're taking before agreeing to proceed and being required to pay money. But if an estimate is over $200, public body can request a deposit before proceeding. So that's just something to be aware of. For larger requests, they might sort of require you to pay money before you receive records, and when they do that, it tolls their timeline in terms of their ultimate production. So you have to pay before the process moves along. It sort of puts a little pause in there. So that's just something to be aware of. And I will say I've personally been seeing more agencies seek these deposits up front. I think it's tough to sort of extrapolate over across the board, but this is an issue I'm kind of interested in seeing how it plays out, and how common these deposits are becoming, and if there's been an uptick in the requirement. I guess with that, I'll kick it over to Megan for now.
Thank you, Ian. That was, very thorough in a short amount of time. Thanks for having me, everyone. It's nice to see some familiar names on the attendee list. So 2023 was a pretty light year at the General Assembly for changes to the Freedom of Information Act. They did do a requirement that you have to post a FOIA fee policy on your website. I would suggest that you test that out in your coverage area, because when we did a survey of state websites last winter, we found that very few had all the elements on their website of what you're supposed to have as far as your FOIA rights and responsibilities. So check that out, see if they've got a new FOIA fee policy and what that policy is. Another thing was that they have removed the parole board's exclusion from FOIA. So FOIA applies to everyone, except at the beginning, there's this provision that says the following are not even subject to FOIA, so don't even bother. The parole board's exclusion was taken away. That doesn't go into effect until next year, though, July 1st, 2024. But that was pretty significant. There's several name changes that went into some of the exemptions. They're calling the former Eastern Virginia Medical School something different. They changed that name. And then there are two bills that started out the General Assembly session as mandatory bills on requiring them to accept credit card parent payments and requiring them to state agencies to provide electronic access for the public. They both got watered down to May. And so the statute already allowed both anyway. So they are pretty much worthless bills now. But that was really all there was in FOIA, though there was a provision elsewhere that takes judges' names off of public databases. And what this primarily affects are land record databases. So if you're trying to verify whether someone, a judge is conflicted or is the same John Smith who was just involved in an accident, you're not going to be able to use the land records database to verify that. As for 2024, VCOG does have a few bills that we're shopping around right now that have to do with the amount paid for settlements at the local government level, some bad advice being shopped around state agencies about redacting the name off of credit card statements. And then we have some pretty technical ones here and there. One is that if you're a lawyer and you're the FOIA officer, you still have to get FOIA training, because we're seeing a lot of lawyers saying, hey, I don't have to give myself FOIA training. So, and one helpfully cited said the same thing in Latin just to prove that he was, one of those lawyers. So, on the horizon, though, for other bills, there were 4 Supreme Court cases from Virginia in the past, since the last legislative session. And there's a lot of hand-wringing among local government in particular about them, 3 in particular. And so we expect there to be some legislative proposals related to those, to trying to address the Supreme Court rulings. Because of the Democratic takeover, we expect that there are going to be some criminal justice reform type bills that could implicate disclosure. We're not sure. Those can go either way. They can be like disclosing police, disciplinary records, but they can also be about expungement and protecting names of victims or witnesses or people seeking restoration of their rights. So I would also just really encourage you to write about these bills, even some of the arcane ones, because just remembering that because FOIA is a law of general application, if you're going to have trouble getting information, if these bills affect your ability to get information and records, it's going to affect the public's ability as well. So that's what we got for 23 and 24. As far as I know that Ian's got some of these, I'm going to go over a few that I see, questions that come to VCOG. And these are ones that I see from reporters more. Some of the ones I get from individuals can sometimes be similar, but not necessarily. One of the things that I'm seeing is the manipulation of deadlines to accommodate an event, usually a public meeting. Something controversial is coming up on the 15th. You've asked for some records that are related to this controversial decision. You've asked for them well in advance, and they extend and drag their feet and put up, we need you to give us your address, and we need you to give up a deposit, and we need the 7-day extension, and I thought that started on Thursday, not Friday, and so on and so forth. And then the decision gets made, and they don't have, and then the need for the records is almost moot. But just be aware of that. Just really stay on those deadlines. The redaction of names is a huge issue right now. It can manifest itself whether it is the name of an individual who's appearing in an email. I'm writing an email about Ian, and they're redacting Ian's name. There's no exemption for that. And if you press people on it, they'll usually just say privacy, but there's no privacy exemption in Virginia FOIA. And then we're also seeing it in terms of redacting the names of public employees. The most glaring is going on right now, in Henrico, Hanover and Chesterfield County, where the names of police officers are being withheld because they might one day be undercover officers. I've seen it in Chesapeake, where it was redacted as a personnel record, where police officers had euthanized a deer that had been killed on a public roadway. So just a lot of, it's usually law enforcement, but not exclusively. But there's a lot of attempts to redact the names of people. We're seeing a lot of economic development records being withheld, the most notable being in Fauquier County, where the Amazon data center is being proposed, and Amazon redacted all their site plans, and the county the town of Warrenton, excuse me, that accepted it and just said, okay, we'll take whatever you say. That's a little bit different from them just going ahead and withholding on their own information that they characterize as economic development. But be aware that that's a real handy and easy one to cite, because they can say, oh, well, we can't tell you about the economic development, so anything could potentially be economic development. So keep an eye on that. Also committees, this is for meetings, not for records. For those of you who cover school boards and city councils, a lot of 2x2 meetings, a lot of committees of 2. And then we have a lot of groups that are created by individuals. And that's a little quirk of Virginia's definition of a public body. It says, oh, if this task force got created by the public body, then it's also a public body. But it doesn't mean that if the mayor creates a task force, that's not a public body, because the mayor's not a public body. And I know that sounds just kind of ridiculous, but that has been upheld in several different instances. And so being aware of that, you see a lot of head honchos, sheriffs or mayors or superintendents creating these task forces that they know will not be subject to the meetings part of FOIA. Any records they generated would still be subject to the records portions of FOIA. And I think, Ian, these are the next two are ones that you see a lot.
Yeah. And I sort of already mentioned a little bit about sort of these earlier demands for deposits. So I think that's something I've noticed a little bit more recently. Particularly what I find concerning is when they're being made in the context of FOIA requests that we're pretty confident the agency intends to deny in full anyway. So, in the past, my experience, agencies have been, they've gone through the process, we put in the request, they've responded in 5 days, seeking the additional 7 days, and then ultimately they provide a response letter citing, whatever exemption they're going to cite, and concluding that all the requested records fall under that exemption, they're not going to produce anything. So that's sort of what we've seen in the past. But now, more recently, it seems like the agency is seeking the deposit before sending the response, right? Before denying everything in full. And it's difficult. I don't really know what's going on, but it just seems like it has the potential to sort of require the requester, the journalist, to pay the deposit before getting the denial to ultimately challenge in court. So it just seems like it could be an additional hurdle, that are being imposed, on journalists, other requesters. Just another step you need to run through, and you need to pony up money before even getting to the denial and going to court. So that's just something I've seen a few times now. I don't know how pervasive it is or how prevalent, but it's just something I'm curious in monitoring moving forward. And lastly, what I see relatively frequently are just agencies that are failing to cite the specific exemptions that they're citing or that they're relying upon, I should say. So in these cases, I fielded requests to the hotline trying to figure out, what is the agency doing here? And, we could sort of look in the statute, try to figure things out, but, the agency is required to actually, cite a specific exemption. So oftentimes, we've gone back, we've asked for more details, and then they will follow up with sort of the specific provision they're relying on. But that's just something to be aware of. I think if you see that type of response that doesn't provide enough information, you could always follow up, always ask for more information. And, like they're also required to describe, what they're withholding, like the number of documents they're withholding, pages and things like that. So, that don't always do that, but that's also something you could push for. Just, they're not being as forthcoming with the information they're supposed to provide, even in the context of a denial or, withholding. So you can always, like I said, always just try to seek more information if possible. I guess I'll get back to you for some of the misconceptions, Megan.
Misconceptions, yes. So just want to, I get asked this a lot, is Virginia is the worst? No, Virginia's not the worst. It's not the best either. On paper, as Ian mentioned about the deadlines, Virginia's got some pretty good deadlines. And then on paper, we've got some pretty, some penalties that some states don't have any penalties, essentially. So what ultimately matters is the culture of compliance, and so how the provisions are being implemented. I'm not making excuses for Virginia's FOIA, but just be aware that, it really is about interpretation rather than the words on the page, and the people are the worst, not the law being the worst. Another misconception that I see is amongst some of the press is that FOIA is just inside baseball that the public doesn't care about. And so there's sometimes a reluctance to write about some of the problems that you've had getting information. And I would argue that, again, if you can't get it, the public can't get it either. And so they need to know that their government is keeping things from them. And so I encourage you to write about it, because they do care, and I hear from them every day. That's how I know that they care. Be aware that there's not anything called a formal FOIA request. Sometimes there's a misconception on both sides of the aisle on this one, that sometimes government will say, well, you've asked for it orally or something, and they say, well, you need to file a formal FOIA request. No, actually, when you've made your verbal request, that is a FOIA request. And, as Ian said, it is best practice to reduce it to writing, but you can write it in any format that you want to. You don't have to file it on their form or anything like that. Likewise, I have been contacted by reporters who have been asked to, they said, oh, well, they won't, they told me to file a formal request, but, that's a violation of, I'm not even quite sure what the argument is, but they're so used to getting things handed to them. And I don't mean that in a mean way, just like because you've got a source. And so you go, hey, Betty, can you hand me that report? And they give it to you. And that's great. But sometimes they want a record and they want you to actually put it in writing. And that's not a violation. They haven't done anything wrong. It's so you're all on the same page, and it ultimately works, to your advantage to have all that stuff documented. Ian already went over the fact that sometimes a fee request a fee estimate is just an estimate and not an attempt to make you go away. Sometimes the request is just big and it takes a lot of effort to get through it. Sometimes it's not, but just don't assume right away that because it's a big number, that it is necessarily unreasonable. Look at the request and look at what's been asked for and see what's involved in processing it. Listen to citizens who are making FOIA requests and or speaking up at public meetings. They have some really good stories. I refer them when I can to local reporters, but I've seen them dismissed very often. And I know that there's limited resources and limited news space. But if you have a break in your schedule, in your news a whole, think about some of these citizens who are doing some hard work. And I know I'm kind of all over the place, but my last one would be a meeting agenda cannot be relied on. the FOIA doesn't require an agenda, and so an agenda can look like anything, and they can amend the agenda at any point. And maybe their agenda says they're going to go into a closed meeting to talk about something. That's not the motion to go into the closed meeting. The motion that you need to follow is the motion that is made at the meeting. So just, agendas are great for giving you a general heads up, but don't count on them in terms of things could be added that you are not expecting them to talk about, and those could be consequential. You really have to show up, because they can and they will change the agenda at will. So I went through those pretty quick, and moving on. And if you, well, if I can, since this is something I said, there's a question that says, if an individual, can you repeat about the individual creating the task force? Yeah, it's just really wonky. The statute says any public body and the committees and subcommittees that it creates, all of those are public bodies and have to follow the meeting rules about notice and minutes and closed session certifications and such. But when an individual has created it, the individual is not a public body. So if they create a task force, that doesn't meet the definition. It's an individual who's created a task force, not a public body who's created another public body. I know, wonky and circuitous, but that's what it means. And it means that they don't have to follow the meeting rules. But if they generate any records, all of them have to respond to a request for records. I hope that cleared it up.
I guess we could, we'll field additional questions, but we just have the contact information for both the BPA hotline as well as VCOG and Megan up on the screen. So I guess we'll just leave this up for now. And field some questions. I said another question about request for record that is withheld because it is part of an ongoing investigation. I think this is a tough one, and sort of the way that these responses are phrased sometimes, I think it sort of implicates like one of my other points, where the agency isn't being very specific in terms of what exemption they're relying on. So there are a few exemptions that relate to investigations. I mean, the main one, relates to criminal investigative files. So that one has been tinkered with a lot over the past few years, and I think the current state, and Megan, I don't know if you agree, but I think it's pretty tough at this point for somebody who's not a relative or somebody like that to get sort of these criminal investigative files. I think there's a distinction between closed and open, but I don't think it's that different at this point. I think it's very difficult at this point for criminal files. This is just a tough one. I don't think I have like a ton of great advice on this piece. There is some good movement towards getting stuff for completed criminal investigations that was walked back. But there are other exemptions that come into play with various administrative investigations. So there's a whole sort of section of the statute that breaks those down. A lot of those exemptions are tailored to specific agencies, like specific agencies, it speaks directly to some of the stuff they look into, but then there are sort of broader ones like for auditors and things like that, like outside auditors. So it just kind of just depends on the investigation, if it's criminal or not, and what the agency is, what the records are. Let's see another question here. I mean, I think the answer is that no, as long as the requester is resident of Virginia. So, the statute does have this requirement, which, I think we could, kind of dispute the sort of the sound-mindedness of having this requirement. But, the statute requires requesters to be residents of Virginia. It was, actually litigated a few years back, went to the Supreme Court, the United States Supreme Court, which found that this was sort of a valid requirement. So that's in place. But aside from that, you don't have to justify your request. You could make a request. I don't see why an agency would be able to make that distinction other than with residency. And even if you are a resident of another state, if you're outside of Virginia, you could always work with somebody in the state, to submit the request. There's like online, platforms. I think like Muckrock is one that has sort of like a proxy system where you could, work with them to submit, a request via their proxy. So I think there's ways to like attempt to get around it, but yeah, I think the only possible justification in my mind is that one. I mean, Megan, do you agree with that?
Yeah, I do. And the question was about, is there anything that allows public bodies to withhold requests from freelance journalists because they're not employed by an accredited media organization? And yeah, the general answer is no. The out-of-state stuff is different. And if I would, Ian just mentioned Muckrock and proxies, I would encourage you all to be those proxies for out-of-state media, because it's a ridiculous requirement, and they would really like to have people who, and I can refer people to you to make the request for them. So it'd be a good thing to do for your fellow journalists. And then the rest of the question was, are public bodies allowed to ask what's your connection or reasoning for wanting certain records? Yeah, they can ask. You don't have to tell them, though.
Yeah.
Why you might want.
Yeah, I'm sorry, I didn't mean to cut you off there.
Why you might want to tell them what it is you're looking for is because sometimes we think that government records are certain ways, or that they have certain things. And by talking to the people who have the records, you can actually find out that, that it's not what you thought, and that what you're really interested in is something else. And so you just have to make that a judgment call each time as to, if they're trying to ask you because they're not going to fill your request unless you tell them, that's right out. But if they're asking you, you can decide whether it's worth it to you to tell them, or whether or not to just say, no, I'm good, but go, thanks.
Yeah. And I guess the other context sort of related to that is, perhaps in a situation where, the agency has sort of a discretionary exemption that like they might be willing to exercise the discretion to release pursuant to some type of conversation like that. I could perhaps see that coming up, but again, like generally, there's no requirements as to that. But I agree with what Rebecca just said for sure.
Well, I don't see any other questions in the Q&A box. So I guess we will give people just another minute or so. In the meantime, while we're waiting, I want to thank both of you, Megan and Ian, for being with us today and sharing your knowledge and expertise with everyone. And thanks to our attendees for joining us and participating by asking great questions. There are a number of resources available to you when you have questions about FOIA, whether it's through the VPA FOIA hotline, the Virginia Coalition for Open Government, the VPA member portal, where we have additional FOIA tips and training available, or the VPA Reporter's Guide to FOIA that was mailed to newsrooms a couple of months ago. If you didn't get it, please email me at deanam@vpa.net. You can also contact the Virginia Freedom of Information Advisory Council. The VPA hotline can be reached by calling 804-495-3144 or emailing FOIA@vpa.net. It looks like we have another question in the box. I'll let you all answer that before I can conclude the webinar today.
It looks like it was just a compliment, so
Thank
thank you.
you.
But
Yeah. Yeah, thanks for
I
having me.
and if I could make one other plug for the VCOG website, because the General Assembly session is starting up. I know VPA maintains a chart of bills being considered that year, and VCOG does too. And so check them both out. And one thing that might be helpful on the VCOG site is that we also still have our charts from the past 15 years, I think it is. And so if you're looking for some sort of background on, how often things happen or when's the last time this happened, or what legislation FOIA legislation a particular legislator may have introduced in the past, you can check that out. But
All right, well,
thanks for
before
having
we go, on another note, we hope that you all will join the VPA on Thursday, December 7th for our virtual VPA Day in the Capitol events. VPA Day kicks off at 9 a.m. with a 2023 election wrap-up with Ken Stroop, Associate Director and Chief of Staff at the UVA Center for Politics. He will provide an overview of the political and policy impacts of the election and what it means for Virginians. The second session is titled Legislation 101, and that's going to be presented by Amy Perrin-Cyber and Catherine Ford of Commonwealth Strategy Group. They'll provide a full tutorial on the entire legislative process, including how a bill moves from its initial introduction through all the various steps that ultimately lead up to a final decision by legislators. You can visit the VPA website to sign up for VPA Day in the Capitol, and you can attend one or both of these free sessions. Registration links are in this morning's VPA newsletter, and they are on the VPA website. I'll be sure to send all of you today some information in case you want to go ahead and save your seat now. And again, thank you both for being with us today and everyone who attended today. We hope to see you at VPA Day in the Capitol and at future webinar training that VPA offers. We'll send you a video link to today's session, a survey, and today's slides after the meeting. Thanks again, everyone.
Thank you.
Bye.